Are we set? Fantastic. Well, welcome everybody to this panel on debating free speech, charting the gap between US and EU online content regulation. It's my great pleasure to welcome such a great panel. But first, thank you very much to Adriana for putting this together, for inviting us and for having us. I'm very excited about this discussion, and not only because this has been a hot topic recently in the news and everywhere, but because I'm personally very interested and invested in the underlying structures, in the incentives that the regulation sets, in the ways and means in which we can contribute to a more inclusive, better, and more satisfying social media environment. It's my great pleasure to introduce three great speakers. Lucien Castex. Lucien is a researcher at Universite Sorbonne, Nouvelle, and a public policy representative at AFNIC. Amelie Heldt. Amelie is a legal researcher at the Leibniz Institute for Media Research, and a researcher at the Humboldt Institute for Internet and Society, both in Germany. And in alphabetical order, last but certainly not least, Olivier Sylvain is a professor of law at Fordham University. His research mainly focuses on communication law and policy. Welcome everybody, and thank you so much for joining. I would like to kick off this conversation by bringing all of us on the same page with respect to intermediary liability. I think it's important when we have these discussions to make sure that we all understand where we are at the moment. And with that, I would like to hand it over to Olivier. And maybe, Olivier, you can give us just a brief overview of what the current situation looks like so that we can better understand where the problems are and what we need to potentially change, or maybe not. Olivier, over to you.
Thank you, Nick, and thank you to Adriana and everyone at the Fletcher Schools making this possible. It's my pleasure to talk about intermediary liability and the current regulatory regime in the US, because it is such in flux, so in flux right now. It's hard to really put this, summarize it in just a couple of minutes. After all, people commit their lives to studying it, but I will just spend a couple minutes to set out the landscape in the US. In the 1990s, as within Europe, there was an emergent concern that prevailing common law remedies and prevailing civil law remedies were not well suited to the emergent network information environment. Congress passed the Telecommunications Act of 1996, and in it included something, an amendment, the Communications Decency Act, which amended the Communications Act at Section 230. 47 USC 230 for those of you who are want to look it up, and that provision sought to create it's titled a Good Samaritan protection. It sought to create a regulatory environment that would encourage intermediaries to moderate content, but would do so on the premise that they were the best ones to adjudicate the question, and that government regulators and that public law would not be well suited to it for fear of chilling innovation and speech online. So what does that mean? In 1997, a foundational case by the Fourth Circuit, the Zarin AOL versus Zarin case, the Fourth Circuit decided that Section 230 entitles intermediaries to an immunity, even if they fail at or neglect to take bad, unobjectionable content down. And the reasons for it are because Congress wanted to encourage unfettered, unencumbered speech online. The people responsible for the speech, the originators of the speech, would be liable, but the intermediaries would not. And off the internet goes. The prevailing view is that user-generated content would populate the internet, and that intermediaries would make the connections between users possible. The standard, for those of you who care, after 2008 decision by the Ninth Circuit, is whether or not an intermediary materially contributes to the content. Only then would they be held liable. Today, this has become a controversy because 1996 is not 2020. In 2020, the prevailing business models complicate things. More than that, this has become controversial because intermediaries, as hard as they try through their automated decision-making systems, are not able to take down disinformation, right? As rapidly as one might hope. Disinformation that could accelerate and metastasize into genocide, as in Myanmar, when people are sharing false information, bigoted information that propel paramilitaries to go after people, or in the United States, right? Disinformation about elections, strategic disinformation targeted at certain populations to promote voter suppression, and things I've written about, mechanisms that perpetuate discrimination in expressive content, like in advertisements. So that's where we are today. You know, there's really so much, Nick, I could say about it, but I think that's the most I could try to put in a couple of minutes.
Thank you so much. This is incredibly helpful. And if I understand you correctly, where we stand right now is basically intermediaries are not liable for the content that users post, even if they know about it, with certain exceptions that we don't need to go into in this detail. But to contrast, over to you, Amelie. What's the legal situation like in Europe at the moment, and which direction is the debate going?
So first of all, thank you so much for having me, and I'm really glad to provide a few insights to this discussion. So the situation in Europe was actually very similar, was very similar until recently to the US, where so we have a provision in the e-commerce directive, that is Article 14, that is very similar to the liability exemption, and was also, I mean, it's from 2001, so it also dates back to a time where platforms should not be held liable for user-generated content. Now this directive is still in place, but at the national level there have been changes, and well, mainly in Germany. Germany passed a law in 2017 called the Network Enforcement Act, and this law was adopted, and well, platforms ever since have to remove manifestly unlawful content within 24 hours and have to provide users with a tool to file complaints against or to flag content. So this already has changed a lot. There have been many discussions about overblocking or over removal due to that law. So far, there's no evidence for that, but still it's considered very speech restricting. Now, I guess what is important in this discussion is really that in Germany and in Europe in general, legislators are allowed to pass or to adopt speech restricting laws, which is not allowed in the States. So what the NetzDG does is that it forces platforms to act on content that is illegal, so it's unlawful by law, and it's mainly, or it's only criminal law. So an example would be libel or incitement to violence, for example, and these laws can now be enforced by platforms, but only in a way that they would remove the content. And this has led to a sort of, movement of platform regulation in Europe, I'd say. There are many in other countries, but also in Europe. Interestingly, France had a similar law or a similar bill, the Loi Avia, but it was annulled a couple of months ago. Maybe we can talk about that later. But there's also the upcoming Digital Services Act at the EU level, which will eventually replace the e-commerce directive. So there might be several changes coming up within the next year, and so the situation, which used to be pretty similar in the US and in Europe, is now changing, I'd say. Yeah, so far for this brief introduction.
Thank you very much. So just to summarize, so we have two regimes, one that Olivier summarized, a regime that gives a blanket immunity to intermediaries in all but a few cases that have been carved out so far. Amelie gave an overview of 14 of the e-commerce directive, which is, I guess, in the US best described as a publisher's liability regime, where if you notice the platform, if you give notice to the platform has to act. And I think the word is expeditiously, if I remember correctly, in the text. And then Amelie also mentioned the German Network Enforcement Act that has an interesting interrelation with 14 of the e-commerce directive, and which obliges platforms to create a process to remove information that that violates certain sections of the criminal code. Amelie also pointed at a French law, and maybe this is a perfect opportunity to bring in Lucien. Lucien, can you tell us more about this new and now struck down French law, how it worked, and its relationship with the e-commerce directive?
Thank you, Nikolas. Indeed, there is a few pieces of legislation in France within the global reform of the Digital Service Act, which is quite interesting because a number of stakeholders are considering that, for example, online platforms have become too big to care, and a number of European stakeholders and countries are proposing new legislation, including France, which is quite interesting. To be quick, I'll shed light on two legislation. The first one is one on disinformation. Basically, I mean tackling fake news online. So the law aims to empower judges to act very quickly and to remove fake news during election campaign. So that law is dating back from 2018, imposing new transparency obligation for digital platforms. So, for example, regarding sponsored content and stuff like that. Also, the law creates a duty of cooperation for online platforms, and the French audiovisual regulator, the CSA, Conseil supérieur de l'audiovisuel, is in charge of checking for compliance. There is also a new legal injunction aiming basically at stopping the spread of fake news. And in practice, you have an interim judge which will qualify the fake news following a number of criteria. The fake news must be manifest, obviously, deliberately and massively broadcasted, and it should lead to disturbance of the peace. So that's the first law on disinformation. The second piece of legislation is indeed on hate speech, is aiming at countering online hate trade, and is in French law, has been in French law basically declared partially unconstitutional on June 18. The majority of the law, basically, most of the provision are being invalid, but still a few articles alive. For example, an observatory of hate speech. And before that, basically, the law was aiming at tackling hate speech by imposing an obligation to platform to take down content within 24 hours if it's deemed manifest illicit. Thank you.
Thank you very much. So this was a fantastic overview of the legal landscape that we're discussing here. And this is also a great opportunity for me to introduce Julie Owono. Julie Owono is the executive director of the Internet Without Borders. She is on the Facebook Oversight Board, or a member of the Facebook Oversight Board. She's also a Digital Civil Society Fellow at Stanford University and an affiliate at the Berkman Center. It's a great pleasure to have you here, Julie, and we will loop you right into the conversation. I wanted to follow up with all of you with the incentive structures that these legal regimes create. So much of the criticism on both sides of the Atlantic has been related to the lack of the social media companies, the lack of the social media platforms to act as swiftly and as forcefully as some people wished they would act. And now my question to you, and maybe we start with the US, again with you, Olivier, what kind of incentives does Section 230 create? And maybe adding to that, does it create the types of incentives that back in the 1990s, when this statute was created, that we wished it would create? Is it working the way it should be working?
Thank you for that question, and it's great to see Julie here on the panel with us. I'll start with the second question about whether this was envisioned in the 1990s. No, it wasn't. No one was thinking about mass disinformation. No one was thinking about the ad-based business model that animates the work of so many of the dominant intermediaries. So I think that's an easy answer. And why is that? And that gets us to the first part of your question. And the incentive structure is variable. So some intermediaries are committed to, again, basically moving forward on a business model that creates a market for user data, which in my mind is really what is animating so much of the ways in which information gets shared and proliferated to optimize user engagement for advertisers. That might be why the intermediaries were, the dominant ones at least, were as reluctant as they were to move quickly on provocative material and content. Content like mass shootings, live streaming of mass shootings, as in the Christchurch episode, or other kinds of content that isn't as heinous, but also violative of core public law norms, like disinformation, fake news, as Lucien was discussing, and other phenomena. And because their incentive has been to optimize user engagement, one can understand that they would not take content down immediately. The incentives have changed, though, and I think this was partly envisioned by the framers in the US, at least, in the conception of a self-regulatory regime in which the intermediaries would decide how to moderate content, and not law and policymakers or judges. There was a view that there'd be different kinds of moderation models. It'd be something like a market for moderation. And so I do think we are seeing some of that today. Twitter and Facebook have decided to, as of today, both intermediaries have decided to take down political advertisements, right? Facebook has been slow to the move, but as of yesterday, has decided that that's the case. Whereas Parler, for example, an emergent intermediary started by folks who are worried about conservative bias, will have a different kind of point of view and perhaps not motivated by the same sort of considerations. In any case, you can find different intermediaries that are moderating content differently. Reddit looks different from Facebook, looks different from Twitter. And so in some ways that might have been envisioned, but I do think that the incentive structure today really does explain why these companies, as Lucien was suggesting, have been slow to take down content. One more point on this. Julia Angwin, who's a fantastic data journalist, who started an organization called The Markup, does a lot of data journalism, recently posted something which I think is exactly right. The most important people in the ecosystem, in the online ecosystem for moderation, have not been the intermediaries themselves, because their incentives, as I said, are a little more complicated. It has been journalists and civil rights organizations and research organizations that have disclosed the ways in which moderation has gone afoul.
Thank you very much. Julie, you probably have a great insight into the incentive structures that, that the legal regimes create. Could you elaborate a bit on where you think we stand in terms of the incentives that are set by the regulatory regime? And feel free to either focus on Europe or give that a more global perspective, whatever you prefer. But I'd be very interested in your take. And then again, same question as to Olivier. Do the incentive structures work the way they're intended to work?
Yes. So first of all, good morning, everyone, and apologies. I got my time mixed up and time zones particularly. I didn't count very well. So I'm very pleased to be here. And I would first of all agree with what Olivier was explaining, and probably in a different sense, in the sense that this inflation of regulatory inflation, is probably also leading more platforms to understand that they do have to accept that finally they do have some responsibility, and that therefore they also have to be creative, not only in creating the tools, but also to make sure that the tools that they put on the market and have accessible to users, because, well, I think there needs to be more thoughts on the positive impact that the platforms can have. And with that, I think we see an interesting move towards platforms coming in with solutions, probably solutions of their own, particularly self-regulation. We've seen that a lot very recently. We see that in the terrorism field, anti-terrorism field. We, to some extent, also some would argue that the other side word is some sort of self-regulation, although I would slightly disagree with that, and I'm happy to explain why later. But yes, it's interesting that this regulatory increase has forced also platforms to have this moral reflection on their responsibility and what solution they have to come up with. From a more global perspective, I'm afraid the incentive there is probably less positive. I feel like until very recently, the US and the EU were beacons of this, this idea that the internet was unfettered, that it would, that there were no limits, anybody could do anything or almost. But increasingly with all these debates around, of course, the debates that were born out of, the chaos that platforms have caused in certain situations, we are swiftly shifting from that position. And so in this more global debate on what is the internet and what is the philosophy that should govern or that should drive the internet, I feel like there is some, the dichotomy between the model, the liberal model, and the other one is probably, narrowing a little bit, at least from the content debate perspective. And I think that's an interesting time. I don't know where that would lead us, but obviously from a more global perspective, it's I should say, to some extent, worrying that some governments, especially in the US and the EU, are, choosing a more restrictive, are more restrictive with regards to, at least when it comes to content. So yeah, I don't have any final solution on that, but what I would say is that definitely it has incentivized platforms to be more creative from their perspective in bringing more solutions, and obviously this will have an impact globally as well.
Thank you so much. And as we've already explored before, intermediary liability is by far not the only piece of the puzzle that defines the incentives of platforms. Amelie and Lucien both have mentioned laws in Europe that contribute to this puzzle of incentives. And Amelie, maybe you can dive a bit into what kind of incentives does a law like the German Network Enforcement Act, that has been copied in other jurisdictions, or not, if not copied, but used as an inspiration by other governments. What kind of incentives does that create for platforms? And how do those incentives play out? Do we already have an idea how they play out, or is it still too early to make that judgment call?
Thank you. So I think the incentive was to indeed remove hateful speech or hate speech, or at least what the crimes punished by the provisions in the criminal code that would be can be attributed to hate speech. The problem is we don't really know. So the platforms are supposed under NetzDG to publish 2 transparency reports per year, but we still don't, and there was an evaluation of the law after 2 years, so it has just been published. But unfortunately, we don't really have the data that would show any sort of overblocking. So really, is the incentive to remove specific forms of content really overly used, or does it have a too big of an effect? I would actually, so because Julie mentioned how creative they are, indeed, Facebook found many ways to get around some provisions of the law. So I think indeed that there are always ways to get around them, and that's not a bad thing, actually. I wonder really if it's the regulation that is an incentive, or if there was just in the past 2 to 3 years public debate and pressure from users, from civil society to take responsibility. And I think in a way, those regulations are a reflection of the public discussion around that. And yes, indeed, the NetzDG now regulated, but I wonder if it was really only the NetzDG, or if there wasn't already enough or a lot of pressure out of that conversation that was happening over the past 2 to 3 years. And another thing is, because Olivier mentioned also a different sort of market for moderation, I think that even if those regulations might lead to more content control, I think something that Sarah Roberts mentions in her work, and that is really interesting, is that content moderation could also be perceived more as a service, and that people would probably prefer using platforms with a sort of good content moderation. Now, what is good and which platform really delivers that service, and especially can deliver it to all users. But I think the problem, one of the issues here is that the big platforms try to be platforms for everyone, and then at the end they're probably for none. So what is political, what isn't? Do we think of freedom of expression, or like as to how it is defined by the First Amendment, or do we see some restrictions as in the European model? So good content moderation as a service would need to have to rely on a specific framework. But I think that's also a way to see it, is that it can be a market, it can be a service, and it can be something that is actually valued and sort of asset as to what people are looking for as a communication platform.
Thank you so much. And Lucien, over to you. Can you give us a bit of a deeper insight into what French regulatory action specifically has contributed to the incentive structure, on top of what we have seen in terms of the intermediary liability at the EU level?
Thank you. Yeah, it's very interesting to be able to discuss the differences about free speech, the US conception and the European conception. Well, basically, the debate in France was focusing on the difficulty to actually reliably distinguish between harmful and illegal content. Most of the time, you are in a gray area. A number of different legal areas are concerned, from hate speech to slander. In France, you have a law of 1881, to, I don't know, to intellectual property rights, to child pornography, and that's a mix. It's different piece of legislations. Obviously, there is criminal law, and the incentive is basically to be able to take down content quick enough, but you can't easily take down content which is in that gray area, hence the difficulty. A number of intermediaries lack basically the legal power to establish the illegality of the content. Also, speaking about the technical community of the internet, a number of them, including CCTLDs, for example, do not host content, and no content actually go through the infrastructure. So it's quite interesting to go from that point. Also, to bump on Olivier's comments, I think one of the main incentives, well, is coming from civil society and from users asking for more control, you know, in the wake of the GDPR legislation and other public debate rising in Europe. You have obviously the DSA, the Digital Service Act, but there is a number of other initiatives trying to bring all stakeholders to the discussion. Just quickly, obviously you have had a number of them in the terrorism context. For example, the Christchurch School, which is championed by New Zealand and France, has created a Christchurch School Advisory Network, which is a start and an interesting initiative. You have also obviously the reform of the Gift City, the Global Internet Forum on Counterterrorism, which was funded like in 2017 or something by Microsoft, Twitter, and YouTube, and which is evolving under new management by Nikolas Rasmussen. And well, basically the civil society is reacting and proposing alternative models. For example, I don't know, interoperability obligation to large platform to foster innovation and allow new entrant to come into play. Basically.
Thank you very much. Now I have two more topics that we can connect, but that I would like to cover. And the first one is the question of reform. In the US, the question of reforming 230 has basically, I would say, at least two sources. One is coming from parts of activists that are specifically concerned with issues like cyber mobbing, like sexual harassment, that say that this broad immunity of platforms is just going too far and is not adequately safeguarding users. The other newer criticism of the Section 230 is coming from the conservative corner, specifically the president. Now, I don't want to go into the executive order and the recent tweeting simply because I don't think there's any substance to either of that. What I do want to go into is substantive reform proposals on both sides of the Atlantic. And maybe I'm going to start with you, Julie. Maybe you can give us a bit of an idea of what you would like to see to happen, specifically with respect to the regulatory framework that you think would best support an engaging but civil digital public sphere.
Yes, thank you, Nikolas. First of all, we all agree, and I think even platforms do agree now, that the time for immunity has passed. We are beyond that. So on that principle, we should agree. Now, where I personally don't agree, both with proposals in the US, but also in many of the proposals in the EU, although the DSA probably will serve something different, is this: there is a dialogue basically between platforms and government that seems to, I wouldn't say silence, but at the very least ignores a little bit another party, which is so important, especially which has helped surface so many of the problems that we're trying to deal with now. And that party is civil society organization, and including academics and organizations such as ours. And I feel that this dialogue is not good for freedom of expression, because ultimately that's what we want to protect as much as possible. This dialogue is, governments trying to modify a lot of governments, including the most liberal ones, trying to modify existing legislation to further political agendas that are not necessarily aligned with freedom of expression. We've seen that in in France, for instance, where although the law was partially invalidated by the the Constitutional Court, Constitutional Council, but nevertheless, we remember the debates on, well, who defines hate speech, especially in 24 hours, and what transparency do you offer that this definition would not actually target more, voices that you don't want to be visible online. That's on the one hand, and on the other hand, we have private companies who that, of course, don't want to be fined, want to protect their profits. I mean, that's what they're here for. They're companies. So, and in that space, that there was very little opportunities for civil society organizations whose work, once again, is being, central to all the efforts that we're seeing now. That voice was completely, at least to some extent, unheard. So what I would like to see is really partnerships between these three parties, because these partnerships are essential and they're how the network functions. This network wouldn't be like it is without all three, putting efforts to build it and to make it as profitable and, liberating for everyone. So hopefully in the future, we will follow what the French Constitutional Court has told us, that in order to make sure we have proportionate laws, legitimate laws, regulation, and legal regulation on content moderation and freedom of expression, we have as much as possible to have all the parties included to make sure that this balance is respected, including the judiciary, but also, again, civil society organizations. So that's my main wish.
Thank you very much, Julie. Olivier had a follow-up to an earlier comment by Lucien, and then adding on that, I would ask Olivier to tell us how he would write Section 230 if he had to write it now.
Thank you, Nick. I think, we don't have to go back to Lucien's point. I was just going to elaborate things that he was saying, not contradict, so we can leave that there. At least because the question you asked now can get us going for a while. There are a couple of things I do want to observe. I very much appreciate Julie's point about bringing a variety of stakeholders in, because they're the ones actually that have been moving the dominant intermediaries with regards to moderation. The one that she didn't mention, but that I don't doubt that she would agree with, and that I think Amelie channeled when she talked about Sarah Roberts's work, is the labor, is the actual human moderators at work here. And the reason that's important is because, that's what Sarah Roberts's work has been about. She's written about moderation as a service, but principally she's written a lot about the costs of moderation, the human costs. And the reason that's important is because these dominant intermediaries never bear the burden or the costs of moderation in a material way, in a kind of commercial way, because they pass them off to independent contractors who we now know suffer PTSD because of all the stuff they have to moderate. If there was a mechanism that brought in labor and accounts for labor in thinking about moderation, maybe it's in a multi-stakeholder body, something like the oversight board, perhaps, but some mechanism that brought in those costs, that would be good. And that's an extra legal intervention, not a legal one. You're asking me about legal reform, and one of the things I very much like, there are a variety of interventions. One is coming from those concerned about conservative bias. I don't take a lot of stock in that critique, because I think they're mostly worried about bigotry. They actually they promote disinformation and bigotry and false information online. I have a hard time understanding when that speech is taken down, when it isn't crossing the line. But the other angle, as you say, is concerned about cyber mobbing and the gendered nature of harassment online. Marianne Franks and Danielle Citron have written principally in this vein. And the reforms that we've seen, I think, are consistent with that. That is, let's find a way that imposes a burden, a duty on the part of intermediaries. And so one regulatory intervention would just to say that you get the immunity only insofar as you take reasonable steps in good faith to take content down. And whether that's triggered by notice or some other mechanism, that would exist. I also very much like another proposal that also distinguishes between the large intermediaries and the small ones, which speaks to something that I think both Julie and Amelie were talking about. That is that some of this stuff is not, so the smaller intermediaries don't have the capacity to do some of the things that the larger ones can as a matter of scale. And so we might just assume that these obligations should attach to the larger intermediaries. And there is an emergent bill that would do that. And one other reform I would like to see, and that is on the table in Washington, D.C. at least, is creating, I don't know if a carve out is the right way to think about it, but allowing for civil enforcement by government agencies of public law. So in the United States, the Securities and Exchange Commission, the Federal Trade Commission, the EEOC, Equal and Opportunity Employment Commission, could bring suits against intermediaries that actually facilitate violations of public law. I think that would help to, in terms of incentives, that would create incentives in the right direction.
Thank you very much. Before we go over to Amelie and Lucien again, I would like to pick up a question that we have received in the Q&A here. Just a reminder to the audience, if you do have questions, please use the Q&A button in the middle of the screen and type it up. Try to keep it short, that's easier to pick up then. So here we have somebody who seems to be a bit skeptical of the involvement of civil society, and let me just read it out. Some have called for framing public platforms as public utilities and thus regulate them as such. What do you make of that? That's the first part of the question. And the second part is, last, while NGOs have been a crucial part of the multi-stakeholder internet governance, would it be possible that they have been weaponized by private actors, namely platforms, as a way of regaining or reinforcing their public legitimacy? I'll hand that over to Amelie, and then maybe Lucien can chime in as well.
Okay, these are two very interesting questions. On the second part, I'm not sure about weaponizing. I think, so first of all, I think that civil society really plays a very important role in this. I've been talking to people at EFF, for example, who told me how often they have actually been asked to counsel and to give advice on how to draft or how to really design community standards or other content standards. And I think that bringing in a variety of NGOs or players from civil society can really be beneficial to that process, and to have a sort of loop how to bring in civil society. I think this work is often unseen, and that's maybe weaponizing, or at least it's interesting to see how little is known about that, and how actually the norm setting process in big platforms is opaque, and what actual role civil society or NGOs can play there is often unknown. So I'm not sure about weaponizing. And other than that, I think we have to public utilities, or also the debate around essential facilities. I think that's very difficult, and I think that as we haven't fully grasped the multi-sided character of those platforms, it's very difficult to categorize them. So I'm not sure about that either, but yeah, I'll pass on.
No, that's very helpful. Thank you. Lucien, we have heard endorsements of civil society engagement earlier on in this discussion on this panel. What do you make of that question?
Yeah, it's a very interesting question, because, well, internet governance is being reformed also. There's been a number of initiatives dating back from WSIS, you know, and a real, a number of reforms of internet governance. Recently, for example, the UN Secretary General created a panel, basically a high-level panel on digital cooperation. I just published this report like last year, and it's interesting because each stakeholder, meaning government, meaning private sector, and meaning civil society, are acting in their respective role to shape principles, norms, rules, and decision-making procedures, to shape and to regulate the internet. And the role of civil society is quite interesting because each stakeholder has his respective role, and civil society is growing up in this role. The question today is, how do you apply that to basically the evolving internet without breaking it? But
thank you for that. And the next question that we got from the audience picks up on another topic or another issue that both Olivier and Amelie have touched upon before, namely the human factor in content moderation. Is there a way to involve civilians in the monitoring of hate speech and bigotry on online platforms, like a grade your partner's paper situation? Are there steps being taken to go beyond reporting posts that go against community guidelines? Olivier, I'll leave that question with you since you mentioned the human factor in content moderation earlier on.
Thank you. I mean, I'd be happy to hear from all the panelists on this, and I think it would be a mistake to leave the Facebook Oversight Board outside of what it means to have human oversight, which is, you know, and it's an invitation to Julia weigh in as well. I've written a paper on this, that when we're talking about human oversight, I take it's a long-standing question we engage in the context of all discussions involving automated decision-making. How involved do we want humans? And there are limits to what humans can accomplish in ways that AI is far more powerful. But there's a kind of legitimacy when we know that humans are involved. Whether as an empirical matter that's a good thing or not, I'm not here to evaluate, but we as a matter of legitimacy think there's something right when humans are involved. And so it happens throughout the chain of the distribution of content. As the question suggests, a peer can report it, but then there's a human at the other end that is, it could ostensibly be responsible for allowing the content to stay up or taking it down. And if it is taken down, there is a mechanism under Facebook's emergent regulatory regime for a body of human actors, including civil society people, academics, and a couple technologists to evaluate that content in consonant with norms, right? So I think it's an overstatement to assume that humans are not in the loop. And in fact, I tend to think it is a glamorized, fetishized conception of what automated decision-making systems do for most of these intermediaries.
Thank you very much for that. And yes, absolutely right. Julie is one of the humans in the loop, so to say. And she is one of the people who will likely shape the structure the governance structure that's evolving. Julie, how do you see the interrelation between people that are involved at your level and then the people that are or how should I say that, a more crowdsourced approach to it, which I think Miranda, who asked the question, was getting at. What is the role of a Facebook Oversight Board? What is the role of professional content moderators? What is the role of simple users beyond reporting content?
Thank you, Nikolas, and thanks so much for the question, Miranda. So 3 answers. The first one about the Facebook Oversight Board. So I think it's important to make a distinction. So the Facebook Oversight Board was not created to make real-time decisions. It's impossible. Rather, that added value of the project is to allow a group of individuals, we're 20 for now, and aim at being 40, allow this group of individuals to sit back. You know, we don't really do that very often when we talk about content moderation because things evolve so rapidly, but we want to take this challenge of sitting back and, you know, reflecting on what are the principles that underlie a specific case and what precedent can it set for other similar cases in the future. And that will therefore guide the content moderators, Facebook first of all, and ultimately the persons in charge of content moderation. So that's really the bet on the Facebook oversight board, making these principled decisions. On the content moderators, from the content moderators' perspective, I completely agree with what Olivier reminded us about Sarah Roberts' work on, you know, making that, valuing that work, which is, as we're speaking, clearly undervalued and not respected. It's a very difficult task. We talk about it a lot. Platforms invest a lot, but definitely not enough in the human, you know, in the human side of things. So that's, I think, the what's important to remind there. And last but not least, the idea of crowdsourcing. It's interesting because the aim of my research here at Stanford and at the Berkeley Klein is really that, to think about, I'm focusing not on the EU this time or the US, but focusing on countries with more fragile institutions where hate speech does have real world consequences, including genocide. We've seen that in the past. So my work is to reflect on how can we proactively, is it even possible to proactively in a country that the platforms don't know? And in this case, I'm working specifically on African countries. We know that the African continent is concentrating so many efforts from all these platforms to bring in their products and to, you know, foster connectivity. So can we proactively, first of all, understand the country, what hate looks like in this country, and therefore can we proactively monitor and be aware of the dangers of when it can become dangerous. But to do that, you cannot do that without relying on the knowledge and the expertise of people in these countries, and particularly professional people, journalists, human rights defenders, and other free expression advocates. And that's the bet that I'm trying to do, how to include knowledge and this professionalism into even the thinking and the design of, hey, we're going to launch a product in, I don't know, Nigeria, Cameroon, whatever, Sierra Leone. How can we make sure that this tool is, allows to moderate content and to see hate speech even before it becomes dangerous? That's really the bet. And I think it's even more important, and we're going back to this question of regulation, it's becoming even more important because it's a profit risk now for platforms. You know, we're working with my organization, we're working on a research paper that will show that in many countries, especially in Africa, the trend of shutting down the internet is becoming even more, you know, focused on social media platforms because precisely of that inability or unwillingness, rather, in some cases, to deal with content moderation problems. So that's why we see where regulation and profits really, you know, become central for the platform. So I hope that answered the question.
That is perfect, and thank you so much. This is the perfect segue to the probably last topic that I was going to pick up, namely the specific interrelation between private governance, meaning content moderation on the platform that is initiated by the platform and under the control of the platform, and the regulatory framework. And with that, I would like to give it over to Amelie. Amelie, how do you see this interrelation play out in the future going forward? I mean, we have seen basically the 1990s where it was all about the private sector needs to lead, to sort of quote Bill Clinton here or his administration here. We have seen an evolution towards a plenty of countries taking a much stricter approach towards directing what companies and what platforms need to do and what procedures they need to follow. Which direction do you see this going, Amelie? Who is going to be the driving force? Is it going to be regulation? Is it going to be the platforms, the private sector itself? or potentially civil society users? You can further expand, of course.
Thank you. So two things from my perspective. So first, I think that from the rule, like talking about the rules that will shape the digital public sphere in the future, they will probably be more procedural, of procedural nature. So I hope that, and we've seen this in Germany, so far the platform regulation has often been associated with content-based regulation, and I don't think that's the way forward, because eventually what happens is that if it doesn't work, criminal law, you will amend criminal laws and make them, make their scope broader, and in the end that means more restriction of freedom of expression, which is, as has been pointed out by Julie, definitely not the goal here. So I think that legislators could contribute to that by drafting more procedural rules, and that would also, of course, involve platforms. Now, a player or an actor that we haven't really talked about yet, or when we talk about regulation, we always think of the parliament, but we haven't spoken about courts yet. And I think that the judiciary actually plays a big role, or has a big role to play here. So far, some of the decisions on both sides of the Atlantic have been not always very clear, sometimes clearing up the situation, but not always very clear. And I think that there's a lot about the status, or how do we handle platforms that need some sort of guidance. It doesn't need to be a clear decision on all the matters that we talked about today, but some sort of guidance of like, this is how we want to go, move forward, and it doesn't need to be specific regulation. So I think that some really strong opinions or decisions on that would be helpful. And I think that courts are in a place where they can really decide on a specific case while giving guidance in a more general way. And so I think that could be a part of what will happen.
Thank you very much. Well, this is a very nice roundup, and we have reached the top of the hour. It was fantastic talking to you. I took away a lot, and the main point I took away is that this discussion is long and will not be over for quite some time, irrespective of what the Trump administration is going to tweet. Thank you so much. Thank you, Olivier. Thank you, Amelie. Thank you, Julie. Thank you, Lucien. Adriana, thank you so much for bringing us together. It was a great pleasure to be here. I hope we all can stay in touch and continue this conversation. And again, thank you so much. Have a good Thursday.
Thanks, everyone.
Thank you.
Thank you, everyone.
Bye.